Welcome to the Immigration Insights podcast. This installment is brought to you by myself, Nick Gore,
Irfan Ali,
Gordana Gligorevic,
Charlotte Roach.
We're all of Carter Thomas Solicitors. In each episode, we discuss the latest news and developments in UK immigration law, brought to you by a leading specialist in immigration law. So, our last episode, we did a whistle-stop tour of 2024 and gave some thoughts on what's going to happen in 2025. Today, we're going to look at how 2025 has started off. We'll also be doing a deep dive into the genuine vacancy test, as well as some developments in naturalisation. So do stay tuned. And last episode, we joked about how in 2024, the Home Office kicked off the year in true style with major fee increases. And it looks like 2025 has followed more of the same trend, including increasing a fee for something that hasn't even started yet. So Charlotte, do you want to take us away on that?
Yeah, so on the 16th of January this year, the Home Office have announced further fee increases. So yeah, like you say, Nick, certainly kicking off the year as they did last year. So the fee still needs to go through Parliament to be approved, but they're expected to come in the spring. And as you mentioned, one of these fee increases is for the electronic travel authorisation, the ETA, which is due to rise to £16 per applicant. So this is the new digital system applying to non-visa nationals wanting to visit or transit through the UK. Its aim is to enhance security and ensure thorough checks on incoming travellers. So it was marketed at £10 per applicant. That's what it currently costs. The scheme started on 8th of January this year and it's already being increased. This might be sort of to do with the amount of work this is perhaps generating for the Home Office. But yeah, that's already going to be increased.
It's often the justification from the Home Office, isn't it? That, we've started rolling this out and it's more work than we thought.
Yeah, definitely. Yeah, so we'll see that might even be increased more as it goes along.
Great stuff. And so it started with some nationalities already, didn't it? And it's being rolled out in full from March, is that correct?
Yeah. So I think the scheme sort of kicked off last year. Sort of been a gradual introduction of more nationalities. So yeah. Then as well as that, we've also had the announcement for the COS fee, which is set to rise to a whopping £525. So yeah, it was only a couple of years ago that the fee for this was, I think it was 199. And obviously we saw it increase to its current rate of 239. And now the Home Office have announced that it's going to more than double to 525. And I think this is quite concerning, sort of on the impact it might have on businesses and workers. We've seen so many changes to the skilled worker route, particularly sort of since April last year. All the increases to the minimum salary thresholds have sort of impacted businesses deciding whether they can actually sponsor migrant workers. And this sort of continued increase of fees might continue to sort of dissuade employers from sponsoring workers. Of course, this COS fee is one of the fees which must be paid for by the sponsor and can't be passed to the worker. So yeah, I think that's quite significant.
Yeah, definitely. So the certificate of sponsorship or COS has to be paid for and applied for each individual skilled worker, doesn't it? So as you say, for each worker a business wants to bring along, it's a big increase on top of the various other fees that have to be paid. What other fees are included by the sponsor, Charlotte?
Yeah. So on top of this COS fee, we've got the immigration skills charge, which is applicable in most cases, and then for the application itself, Home Office fees, health surcharge, priority services if you want them. So all these fees are sort of increasing, and a further increase to the COS fee, I think is just quite significant.
Yeah, agreed. For sponsoring an individual worker, it's what in the region of say, close to 5,000 for up to 3 years, which is quite a big expense. And then if you're being a generous employer and helping them bring their family members over as well, those fees go up and up and up, and that's not even leading to settlement, isn't it? So yeah, it's a huge increase, and obviously part of the various incentives, as you say, to try and reduce the incentive to sponsor workers from outside of the UK.
Yeah, definitely. And then, as you say, sort of, following that route onto settlement, and then eventually, if someone wants to apply for citizenship, officer also said that there's going to be fee increases for that as well. So an increase to the application fee of which I think is going to rise to 1,605. So again, everything just sort of keeps going up. And then there's also been sort of other major changes for naturalisation. If you want to cover that, Nick?
Yeah, I mean, so as you say, first of all, the fee changed, but the process to try and get naturalisation has also changed to some people. So to naturalise as a British citizen is the route that many people coming to the UK want to eventually take. So you enter the UK under your own nationality under various immigration routes, and then you normally have to acquire indefinite leave to remain, often after a period of residence in the UK. Then once you've got indefinite leave to remain or settlement, you can apply to naturalise as a British citizen. As a British citizen, you can of course have a British passport. So for both indefinite leave to remain and naturalisation, there are various barriers to try and demonstrate that the person can be sort of effectively a part of UK society and communities. So there's things like the Life in the UK test individuals have to take, which is quite frankly a random collection of UK history lessons and various values that they've sort of collated into a book. And you also need to pass some practical things like an English language test. And for naturalisation, you have to demonstrate your physical residence in the UK over a number of years. So naturalisation itself is often a bit of a hot potato in political terms, but there's been what was a minor change in the guidance, but has had a huge impact on the process for naturalisation for many individuals. So the Home Office made a change to the good character guidance, which was effective from the 10th of February 2025. This effectively blocks refugees from naturalising. So just as a background to this, this was picked up by our colleagues at Free Movement, who are a specialist immigration sort of website, and we've written for them as well. And it's really thanks to them that this is known in the wider sector, because no one else really picked it up. It wasn't really announced. So the good character requirement is again another factor that has to be taken into account to assess whether someone can meet the naturalisation requirements, and even something as minor as a fine, a speeding ticket, has to be taken into account within that sort of analysis by the Home Office. Now, the previous position was if someone entered the UK illegally, it's normally appropriate to refuse naturalisation where the illegal entry took place in the past 10 years. And so the 10-year period came into effect from 2014. Before that, there was a sort of different waiting period. So if you entered the UK by small boat, for instance, even though they didn't do it so much, in 2013, you'd have to wait at least 10 years before being able to apply for naturalisation if you've got, the various things in place before then: asylum, refugee, indefinite leave to remain. So that's already quite prohibitive. Most people have to wait only 5 years before getting to naturalisation. Now, a seemingly small update was added saying any person applying for citizenship from 10th of February onwards who previously entered the UK illegally will normally be refused, regardless of the time that's passed since the illegal entry took place. So again, it's quite a small change, but quite seismic, the outcome. The Home Office confirmed this position. They said the guidance further strengthens measures to make it clear to anyone who enters the UK illegally, including small boats arrivals, faces having British citizenship applications refused. So it affects quite a large number of people. The refugee organisations believe it could be about 70,000 people won't be able to apply for UK citizenship who have previously held asylum. Those who applied from before 10th of February 2025, illegal entry is a factor, but it's not sort of determinative in the same way that it is for applications after 10th of February. So as I say, this was really only picked up by the Free Movement blog. So there was some concern that this was just added in almost by accident, whether the Home Office actually meant this at all. In the House of Lords, the Labour spokesman talked about this, and they said none of the proposals mean that individuals cannot apply for citizenship. The basic test, there's a presumption that those who enter the UK illegally will not have citizenship approved unless there are specific criteria in the guidance to make a case for their particular circumstances. The effect of the amendment they've made is to ensure that we reduce the amount of illegal migration and ensure that people enter the UK or apply through asylum through legal, strict routes and means. And they also talked about the presumption is that those who have arrived illegally will find their application turned down unless they can provide a range of circumstances which are exceptional, compelling, and mitigating. So again, a lot of confusion because the amendment to the guidance hasn't talked about exceptional, compelling and mitigating specifically. It is all down to the Home Office discretion, but it's really unclear that if you enter the UK age 15 by trafficking, for instance, and you want to make an application now that you're 16 and have got indefinite leave, 26 and you've got indefinite leave to remain, how do you meet those requirements? Because there's not much in the Home Office guidance to talk about it. And again, in the House of Commons, the leader of the House, Lucy Powell, talked about that there are long-standing rules that prevent those who arrive illegally in the UK from being granted citizenship, and we've strengthened those rules in a small way for those who arrive on small boats, so they'll also not be able to become British citizens. It's important we take away some of the pull factors that bring people to the UK, and we take tough action to control our borders. Again, the Home Office and the government really referencing it as a small change, but it's actually had quite a seismic impact. On top of that, on top of the fact that loads of people won't be able to apply for citizenship potentially, there's also a minor point, again, free movement picks up on this, that a refugee can't apply for a passport from their country of origin, even if they've been granted indefinite leave to remain. As by doing so, it leads the Home Office to consider that they have sort of re-availed themselves, so they've got back their protection from their country of nationality, and their indefinite leave to remain can be revoked. So that basically means that if you've got indefinite leave to remain, because you entered the UK, by small boats, because you had a genuine asylum claim, you got asylum, you got refugee, you got indefinite leave to remain, you now may not be able to get British citizenship, and you may not be able to get basically a valid passport, although there are other travel documents. But it just makes it much, much harder to travel in general. So it's a really small change, but it's had a huge impact on various numbers of people, and it's quite a big impact on the sector. And in terms of how it's come about, as we say, it's not been a big policy announcement from the Home Office. It's been a small change that's been picked up by a specialist blog. So it's not even like the government are able to say, look how tough we're being on immigration, because it wasn't announced like that. So it's just a really weird policy. I don't know if you've got any thoughts on this, Irfan, about the people it can affect and what this is all about, frankly.
Yeah, no, I mean, I've dealt with a number of citizenship applications, and previously I've had instances where, I've had people who had, who had entered illegally, but then they basically, claimed asylum, and then they were, they went through the process, and all that was, it all was legalized. And this cropped up as an issue back then, and like you say, Nick, it was still possible for those individuals to to make those applications, provided, of course, that they've done the time, with a 10 years gap. But I think putting this in a position like this now, it's almost as if a lot of these individuals, they can maybe submit an application, but again, they're risking the refusal of an application and the fees that would need to be submitted, because a lot of these applications can be submitted with evidence being put forward, but there's no guarantees or good possible chance that the application would be successful. So I can see this would certainly have a massive impact for a number of people, and it does really put them in a very tricky situation. And I think when you have indefinite leave to remain, there is still always at risk that it can be revoked for whatever, for one reason. So they're never really feeling secure in that sense. And I think for a lot of individuals, they do see getting the British citizenship, getting the British passport is, that level of integration for them, that and security for them personally, and for their family members. So yes, I think right now, I mean, obviously, this may, it just come about almost snuck in, like you said, like you mentioned, Nick. But I think it certainly will have an impact on a lot of individuals.
Yeah, absolutely. We had an inquiry today. Someone trafficked to the UK when they were a child, now trained to be a doctor, but they want to become a British citizen so that they can undertake sort of their practice outside of the UK, for which they need their British citizenship approved. But they're concerned now if they're going to be able to get it. And that's someone who, entered the UK as a child through illegal methods. We can make a good case about the fact that there's compelling circumstances and things, but there's little to no guidance on that specific aspect. So yeah, it's a small change that's had a real seismic impact on the sector, and for seemingly little point. As you say, Irfan, a lot of people want British citizenship for that sense of security, but someone who's already got indefinite leave to remain can already do things like claim public benefits and things like that. So it is just a strange and quite cruel policy, to be honest with you. So yeah, interesting times for naturalisation. But also it came up in the news earlier this month as well that Kemi Badenoch's first major policy announcement as Conservative leader was to sort of bar migrants from settling in the UK in certain circumstances. So as I say, currently the system is that you need to be in the UK normally for at least 3 years and have indefinite leave to remain if you're married to a British citizen, but most of the time it's 5 years before you are able to have indefinite leave to remain and then apply for British naturalisation in certain circumstances. Kemi Badenoch suggested that this should be extended from 5 to 10 years, and under the plan, residency status will not be granted to migrants with criminal records or those who have claimed benefits or social housing. So again, a very specific cohort. And the Shadow Home Secretary Chris Phillips told the BBC, if someone over a period of time has constantly claimed benefits and not worked, then we don't want to give them indefinite leave to remain. And he said that migrants claiming indefinite leave to remain will have to show they were a net contributor to the economy to be eligible for naturalisation. How they do that calculation is beyond me. There's so many factors to take into account in terms of being a net contributor. And it sounds like it'll be, in terms of what we were saying earlier about how a system would be too much work for the Home Office, that would be an incredible amount of work to try and do that calculation, I suspect. And then on top of all of that, Downing Street, confusingly, said that there was very little to no evidence that citizenship acts as a pull factor for people choosing to come to the UK, despite the fact, as I said earlier, Lucy Powell specifically said that we need to take away some of the pull factors of which British citizenship is a point. So if your mind is blown, so is mine. It seems we've gone into a weird space with naturalisation in general.
Yeah, and I think sort of extending that indefinite leave to remain period to 10 years, I mean, that's going to really increase costs for people, isn't it? It's already sort of expensive to keep extending and then go through the ILR process after the 5-year period. But yeah, 10 years would definitely be a burden to a lot of people.
Yeah, absolutely. I wonder if the amount of fees you pay adds to your net contribution to the economy under those plans.
Yeah, you'd
it's
hope
an awful lot.
Yeah.
Yes, so naturalisation, it's always, as I say, a bit of a political football. But another bit of political football is employing illegal workers. So we're seeing lots of sort of news about the government cracking down in various areas about employing illegal workers. Gordana, what's the latest on that?
Yeah, hi Nick. Yeah, that's right. I mean, since last year, the Home Office is really tightening everything. So not only the rules and conditions and fees, but they have a real go and checking the who's employing who, and if the employees of various companies have right to work. So obviously, under the UK law, employers found to be employing an individual who does not have an appropriate visa or permission to work in the UK can face really tough sanctions. So it's not just the fee, there are other implications as well. Employers obviously can protect themselves by carrying out the right to work check before they employ a worker and assign them a task to do. And they would need to do that before the worker starts and get on. But unfortunately, it seems there is quite a few of organizations that do not go through the right to work checks, either do not go through it properly or maybe don't do right to work check as well. So I think there were 2 cases recently where the sponsors were not only issued with the fines but also were banned on being a director or arranging forming the company in the future. So, for instance, there is a owner of the car wash in Lincolnshire. The company was established in 2019, and a couple of years later, the UK Immigration Enforcement came to check, are they complying with their sponsorship duties? And they found a couple of people who did not have right to work, yet they were working, as employees at the premises. The company was fined. I think it was 20,000 at the time because of the immigration breach, but the company soon after entered into liquidation and they did not pay the fee at all. So I think then Insolvency Service got engaged as well, and they basically issued a 5-year ban to this car wash owner. So he is now banned until I think 2030. So that was issued early January this year. So he cannot be a director of the company or form another company until 2030 unless he applies with the court to get an order to do that. And similarly, there was another case where it's a Chinese takeaway restaurant owner who similarly, someone in Scotland, Aberdeen, employed individuals who did not have right to work. So when the immigration enforcement officers arrived at the premises, they found, I think, about 3 people who were working in the kitchen cooking Chinese, but with no right to work at all. So needless to say, again, this person was fined, even though the person who employed these individuals was no longer a director of the company. He was still running the business, so he was fined 20,000 per person. And then recently, it was I think a month ago, that he was issued with, or maybe early February, that he was issued with 7-year ban to be a director of the company. So it's really getting tougher for the owners. And I think the director of investigation and enforcement services at the insolvency service, because of both companies went into insolvency, so that company directors have a responsibility to follow all the rules and regulations expected from them. And for instance, this takeaway owner failed to do that. He employed 3 people who had no right to work in the UK. And obviously illegal working puts even most vulnerable people in society at risk of exploitation, undercuts honest employees. They're not paid enough, the employers don't pay tax and so on. So it's like a kind of vicious circle for those people. And you said earlier that the person who was, smuggled in the UK, sometimes this happened to the same, they get smuggled in the UK, find a job, they're not paid properly, they don't have right to work. In the end, they can end up, being in jail, being deported, all because the employers are using these loopholes and not checking the right to work, or not complying with the rules. So it impacts both the workers who work without the right to work, and also the owners of the business. So as I think it was Minister of Border Security and Asylum said, that anyone who thinks they can profit from illegal working in the UK can think again, because there is no hiding place from the law enforcement. They're bound to find them sooner or later and impose sanctions.
Yeah, absolutely. I mean, we've been seeing plenty of right to work cases enter our desks, haven't we, guys? Across the board, it's been the uptick in activity has been really significant on this, and in a sense, it's really good that they're taking action against these horrendous employers, as you say. People who frankly abuse victims of trafficking and things like that, force them into illegal employment. Right to work checks themselves can be so specific as well that it does often impact sort of genuine businesses as well, who employ someone in good faith but have just undertaking the wrong type of check. So it's often it's taking a sledgehammer to crack a walnut, but in this case the consequences are so severe if you are employing an illegal worker, in terms of the consequences for the individual. It is interesting to see the Home Office take such a strident approach these days as well. So yeah, it's an interesting area, something that frankly the Home Office often haven't done loads of action with, and they really are kicking in gear now. So interesting to see them step up. And then on top of that, there's been some clarifying positions on the type of work that skilled workers, which are the predominant sort of people who work for companies in the UK, can undertake, can't there? Isn't there, Gordana?
Yes, that's so anyone who has got work visa, so mostly skilled workers, but some other visa categories as well, which have right to work, can undertake some additional paid employment alongside the work that they're sponsored to do for the visa. So that's not known as supplementary employment or additional employment. So there are specific requirements for that. For instance, the person has to have a certificate of sponsorship assigned to them, and work for that sponsor that issues certificate of sponsorship. The work should not be more than 20 hours a week, must be after their normal working hours, so probably after when the shift's finished or in the evening, and they have to continue working for their sponsor in order to be able to do any supplementary employment. Also, the job needs to be under the eligible occupational code. So however, supplementary employment also includes some voluntary employment. So unpaid employment. So this was a recent case where the Home Office clarified what voluntary work is required, is allowed, basically. So there was this individual who was issued with the skilled worker health and care visa, and she arrived from India, I don't know, beginning of June. I think it was last year, or 2023. And 20 days later, the immigration enforcement officers came across her working behind the counter at the corner shop, serving customers. So the store owner argued that she's basically volunteering, she's just helping there, she's not employed, she's just there temporarily. And based on that, I think it was no action notice issued. But then afterwards, after the Home Office did some internal reconsiderations and so on, they found that this person is actually really in contravention of immigration rules and of her visa conditions, and they issued, they basically cancelled her permission to stay and issued the deportation order to be removed from the UK. So what actually happened is that, and the guidance also states that people sponsored on work routes are permitted to do voluntary work in addition to the work for which they have cause assigned to them. So that includes volunteering without any contractual obligations for charitable organizations. So the corner shop is obviously not a charitable organization. People doing voluntary work must not receive any payment, and the explanation that the Home Office and guidance give is that the voluntary work corresponds to the definition outlined in Section 44 National Minimum Wage, which says that voluntary organizations for which obviously voluntary work can be done mean a body or person or trustees or trust which is established for charitable purposes, benevolent purposes, or philanthropic purposes. So it's not a charity work or voluntary work assisting to anyone. It's basically assisting one of these specific organization that employ volunteers. And obviously the work that this lady who claimed that she's volunteering at a corner shop did not consist a voluntary work. So yes, needless to say, she was removed, she was asked to leave. And the voluntary work is been all sort of prominently defined in the rules, in the guidance.
Yeah, sure. So yeah, it makes it much clearer that voluntary work really can't be abused, can it? Because as you say, people are sort of saying, "Oh, I'm doing voluntary work by working in this corner shop," when in reality it needs to be very specific. This type of activities that are undertaken, and they link that to sort of wider, almost sort of voluntary law. I think you could almost call it, couldn't you, for instance? Which did make things a bit clearer to try and stop some of that abuse. So yet again, the Home Office taking some interesting actions there. That wasn't the only case, was it, Charlotte? There's been some other interesting ones in terms of decisions that have come from the Home Office recently.
Yeah, so a recent sort of interesting case that we came across was the successful judicial review for a care home in the UK. So this was on the application of Hertford Care Group Limited and the Secretary of State. And yeah, it was a judicial review which involved a leading UK care home organisation. They'd applied for 70 defined cause, which the Home Office then refused. So following the DCOS application, the Home Office requested further information from the sponsor, which we do often see. Their request included official employment contracts demonstrating guaranteed hours of work. So the sponsor provided the contracts, but they did not contain the clauses on guaranteed hours of work. And as a result of this, the Home Office rejected the DCOS application, saying that the vacancies weren't genuine. So in its application, the care home argued that there's no requirement in the immigration rules for official contracts containing guaranteed hours, and therefore that the Home Office's decision to reject the DCOS application on this basis was contrary to the rules and irrational. And interestingly, the court essentially agreed with this and quashed the decision. So yeah, the court said that such contracts simply did not exist as standard contracts in the care sector. And they also mentioned that job vacancies can be genuine without there being such a contract. So yeah, we often see the genuine vacancy requirement coming up sort of on the Home Office assessing applications, and it's very sort of discretion-based ground. But it's definitely interesting to see here that the court's really considered the nature of how care homes operate, and has decided that the Home Office's refusal of the DCOS here on this question of genuineness wasn't justified.
Yeah. I mean, we'll be picking out our genuine vacancy expert Irfan's brains in a moment, just about what that is and what it means. But as I say, it's interesting to see the Home Office actually lose a case, isn't it? Normally they win all of these types of cases in relation to meeting the requirements. Yeah, and as you say, the fact that the court sort of agreed that within the sector these sorts of contracts aren't provided. It's a real sort of real world understanding, which is quite refreshing to see, isn't it, from the court. Often it's just very much a sort of tick box exercise with the guidance. Have you met XYZ requirements? And to be able to actually say this isn't the reality on the ground, it's quite helpful in many ways for the sector to see that the real world scenarios do impact how these decisions are made.
Yeah, definitely. And I think especially sort of sponsors in this sector of care, they'll often see, further requests for information, documents from the Home Office. And sometimes, a care home might be thinking, is this reasonable? We don't have this document. This document wouldn't really exist for us normally. So I think the decision here is quite interesting.
Yeah, agree. And care homes have been a target for the Home Office since the changes since 2022, allowing essentially allowing care workers to be sponsored under the immigration system since then. And as a result of quite a lot of poor practice within the sector, a lot of organisations have lost their sponsor licenses and displaced adult social care workers. But there's been some interesting changes with that, haven't there, Irfan, from the sector and from the Home Office with this?
Yeah, absolutely. Yeah, Nick. And I think there had been some murmurs of basically there's been some workers in the background. But I mean, obviously, as a result of the Home Office taking an increased interest within the care sector, a lot of licenses, so a lot of sponsors have lost their licenses, and that's resulted in a lot of the workers being displaced. So effectively, there's a whole pool of workers there who, through no fault of their own, have been displaced because of issues with how sponsors have been running the organizations. So the Home Office have been working closely with the Department of Health and Social Care, and they've basically teamed up together, and they've been contacting various sponsors within the care sector, basically encouraging them to get in touch with the regional hub, where they can basically, if they're looking to recruit international talent in terms of with workers, with the health and care worker, senior carers, etc., to get in touch with them, and then hopefully the regional hub can then put them in touch with one of these displaced workers. So this is fairly something new that's basically been coming about, and I think there is some benefits as well that the Home Office have been saying. If you do recruit these displaced workers, there's some benefits in terms of application for licenses and certificate of sponsorship to be expedited free of charge. When they so there's definitely some benefits in terms of looking at that, and we've already had a number of clients who've received these and basically looking to explore this option. And I think if ultimately if a business needs a worker and there's a pool of experienced people who can do the work, then by all means something to definitely explore. And on the back of that as well, we've also seen that not only have the Home Office been contacted and sponsored, but they've also now started to contact workers as well who have been impacted by, I mean, some of them, go back to 2023, where the license has been revoked, and the Home Office haven't necessarily done anything with that yet. But they basically, it almost seems as if it's an invite only, but basically they're also encouraging workers to get in touch with the regional hub. They provide all the information within the email or the letter, just saying get in touch with the with the regional hub and see whether they can help you find another sponsor who'll be able to assist with that. So I think so people who are impacted, certainly keep a lookout for these emails or correspondence coming out from the Home Office, and certainly take them up on that if it is relevant and of benefit for them.
Yeah, I mean, it's again really interesting to see the Home Office, using this pool of resources, as you say, in other sectors. If a worker is, basically made redundant because their sponsors lost their license, they're kind of left high and dry, aren't they? They basically need to switch immigration routes or find another sponsor. And it's
Yeah.
interesting to see them taking a more proactive approach with this area in particular.
Yeah, that's. I think the care sector just generally has been very in demand service, and I think because of the action the Home Office have been taking, a lot of sponsors have lost licenses, and I think that's resulted. And generally, what we tend to find as well is, Nick, is that when an organisation loses a license, normally some of them can be sponsoring 80, 100 plus workers, and that and I think when we saw the figures most recently, there was a lot of sponsors lost the license. A lot of them were in the care sector, so I think the pool then just obviously created and it's creating a big problem as well for the Home Office. Well, how do we deal with these pool of people? So I suppose this is one way of looking at it. So it'll be interesting to see how effective this is over the next few over the course of the year, to see whether people are actually getting new jobs, etc. So it'll be something to look out for.
Yeah, absolutely, absolutely. Then Charlotte earlier mentioned the genuine vacancy requirement. So this is something that often comes up, especially in skilled worker matters, which is again sort of the main immigration route for those who want to work in the UK and are tied to a specific organisation. So we thought it'd be useful to do a sort of deep dive into what this is. And Irfan, do you want to take us away and explain to us all how the genuine vacancy works and what it is?
Sure. Yeah. So I think it was so essentially sponsors who are looking to recruit workers, if they're required, they need to they need to be able to show that they can offer genuine employment that meets a relevant salary requirement and skill requirement, the skill level for the route, and that's known as the genuine vacancy test in itself. And the Home Office is helpful as well to just to have a bit of an understanding of how the Home Office define it as well. And this is contained within the guidance. So essentially, they define the genuine vacancy as one which requires a job holder to perform the specific duties and responsibilities for the job and meets all the requirements of the relevant route. It does not include dissimilar and or predominantly lower skilled duties, and is appropriate to the business in light of its business model, business plan, and scale. And we've certainly seen a rise in the Home Office raising genuine vacancy concerns, over the last year or so. And these are not only with individual skilled worker applications, but also with sponsor license applications, and as part of a compliance visit where the sponsor already holds a license. And generally, the kind of things that we've seen are things like Home Office raising questions as to whether the role actually exists. So things like, if does the salary meet the requirements of the role? Does the nature of the role align with the business? Has the sponsor been able to clearly explain the suitability of the role and how the individual was assessed, and whether the role has been created primarily to enable overseas nationals to come and stay in the UK. So these are just a few examples that's basically been cropping up, and it's where the Home Office have these concerns. In the first instance, they may request additional information or evidence from the sponsor, and then they may, in a lot of cases, we do tend to see that workers, are required to attend an interview, if they're of the view that the vacancy may not necessarily be genuine. And generally, what we tend to find with these interviews are things like, they'll get asked questions in terms of, how did you apply? What was the recruitment process? What's the role you're going to be? What's the role you're going to be undertaking? What are your experience? And doing a little bit more of a dive into actually what the role involves, and and the Home Office are basically looking to see whether or not the individual can clearly explain, what the role is and what they're going to be looking to do with that. And sometimes at the back of that, that could then trigger off any other, if the Home Office have any further concerns with the sponsor, for instance, they may want to interview them, or that could also trigger a compliance action for them as well. So I think it is certainly something that's been cropping up, and it is something that the Home Office tend to now, are looking at this a little bit more closely, and it is also now incorporated within the immigration rules as well. And I think previously what we had is that there used to be a market test. That was that was the requirement and the tier two route. Now the skilled workers, but that's no longer the case anymore. But you still need to be able to, and this is all set out in the guidance. Basically, if you advertise a role, you still need to be able to retain that evidence. Go through the process of explaining what was the process. How did you identify the candidate, etc. But it also allows individual sponsors to also hire workers where they not necessarily haven't actually gone through the recruitment process, but the Home Office may want to see, well, you've identified an individual, how were they identified, how do they meet the requirements for the role. So I think it is something that that people do, sponsors do need to be mindful of in terms of just generally with applications. And when you're looking at the roles, I think if you are recruiting for if you go through the recruitment process, it is important to retain the evidence on file. So if a Home Office would ever ask questions relating to that, they can certainly say, like, okay, this is our recruitment process, this is how we this is we advertised here, X candidate applies, these were no good, these ones were put through to interview, and this is our criteria for these for these roles. When you're looking at job descriptions, they need to be thorough and detailed. Generally when we look at job descriptions, we tend to ask for and set out as much information you can regarding what the main role is going to be, any any specific skills, experience, or qualification that's going to be required as well. And I know that the Appendix D guidance, which is the main guidance that the sponsor need to refer to when they're retaining documents, that was also updated recently as well to explain that if your job description make reference to a specific qualification, etc., and then you go on to hire the individual without the qualification, you need to be able to explain or have on evidence why you still offer that position to the role, even though they don't have those requirements. I think ultimately this is it is one of those where you just have to do a little sense check in terms of what the role is, does it meet the requirements. And we often find that when it comes to doing the occupation code, this is where a lot of people do struggle with. And sometimes especially with the changes to the salary requirement, where people are looking to maybe see whether or not the occupation code maybe a better fit, but the salary may be slightly lower and stuff. I think people need to be very, very careful when they are carrying out those assessments, because ultimately the Home Office need to be able to be they need to be convinced that the occupation code is the most appropriate and most suitable for the role that the individual is going to be taking, and the duties that's been on the course is an accurate reflection of the role that the individual is going to be undertaking as well. And I think on the back of that as well is since and the Home Office has somewhat been updated as well with remote working, and this also has cropped up as I think ultimately the Home Office are happy with employers and organisations having a hybrid remote working model and stuff, but the guidance does say that obviously if there is a sponsor who is working entirely remotely, then they do reserve the right to ask them further questions as to basically, is there a need for the role? Can this be performed? Is sponsorship still appropriate if the role can be undertaken from overseas, for example? So I think usually with these kind of things, it is best just to do, just take a moment to have a look at what the requirements are, just making sure that your internal records are up to date, and although you don't necessarily need to provide all the documents with an application as such, but it's good to have it on file in the event that the Home Office may want to query and ask about that. So so it does certainly crop up with initial applications, sponsor license application as well, having a clear understanding of what roles the business is going to be looking to sponsor in, and for any existing sponsors, just making sure that it was everything does align well. So for example, if you got a small business with 5 people, you've hired one business development manager, and then you're looking to sponsor 2 more business development managers, that's going to be like a red flag for the Home Office. So it's like they'll basically look at that business of this size. It's already got 1 business development manager. Why does it need 2 additional business development managers? So so that's where they can see as a big red flag for them. So I think just doing it, it's always helpful to get that sense check done when you're looking at these, especially with genuine vacancy, and just to avoid those common pitfalls.
Yeah, so it's a hugely broad and deep power that the Home Office have, isn't it? Because as you say, you know, they can look into the role in a lot of detail, but also, you know, Charlotte mentioned the case earlier where they looked into a specific part of the contract and said, as that part of the contract isn't there, we don't think the role is genuine. So they can really spread their tentacles far and wide throughout the organisation when trying to make this assessment, can't they?
Absolutely, Nick. Yeah, I mean, there's, I mean, and I mean, obviously, as in that case, it was a perfectly legitimate reason as to why they couldn't find those, those contact clauses, because it doesn't exist. And a lot of the times, that could well be the case. And I think sometimes, I think the Home Office have an expectation to say, well, this is, this is what we expect to see. I can't find this, so that must mean that it's not genuine, and that's not necessarily the case. And I think sometimes, when sponsors do come across these kind of issues, I think it's always helpful to put just put forward that explanation or give a bit more background information as to, well, I've given you what we can. This isn't available because they don't provide such information and stuff. So I think it's just helpful to have that additional information. But you're absolutely right, Nick. I think this does open up. This can open up a whole set of for the Home Office to look into, purely on this specific ground.
Yeah, absolutely. I was with a client last week and we sort of brought this up, and I said, in certain circumstances, as a sponsor, so if the organisation has a sponsor license to bring sponsors to the UK, the Home Office can come in and ask for evidence of the work that the individuals have done and see whether it is of the sort of the skill level that they require. And this client very rightfully asked, who are they to judge? What do they know about the work we do? Why would they be assessing the skills? But that's just an example of the power they have, isn't it? They can come in and say, right, show me all your emails. We're going to say whether we think it's this level, skill level, or this skill level. And if we don't think it's the required skill level, we don't think the role's genuine, and we don't think this meets the requirements. So it can be incredibly tough to meet that. And it's, as I say, it's incredibly at their discretion, isn't it? The Home Office's discretion to make that judgment.
Yeah, absolutely. And generally, in most cases, Nick, I mean, the Home Office who's doing the interviews, they are not experts in in some of these business sectors. And ultimately, I think, if the Home Office are putting forward an argument, and I think the business, are well within the right to put forward a counter argument in terms of explaining, a bit more background in terms of that what they're specifically looking at. And again, I think this all helps having that evidence on file, in terms of if the Home Office will want to have a look at that, if they have, if they, and it's been a justifications as to why the business is taking some sort of action. I think it's, ultimately it's what the business need. Is, there's no one one size that fits all. So I think ultimately you're still having those, just having that argument to put forward to the Home Office if they do challenge businesses on that front.
Yeah, absolutely. And in terms of evidence on file, just make sure you're filing your emails, I suppose. That's one of the main things if they're looking throughout the organization. So yeah, I mean, it's just a good example, I thought, of just how far the Home Office power reaches in terms of this, and just a example of the Home Office always have a very specific line that they always trot out, that sponsorship, i.e. the way that organizations can get skilled workers, is a privilege, not a right, and it's one that the Home Office are often willing to not give or to take away in certain circumstances, aren't they?
Absolutely.
Yeah, great. So thanks so much for that, Irfan. I appreciate it's a complex subject, so it's good to have a deep dive into that. So thank you all for listening. So in terms of what's coming up, we've got another episode next month, of course, to give you the latest immigration insight and news. So stay tuned for that. We've also got a skilled worker and sponsorship system webinar with MBL seminars on the 11th of April 2025. So giving you a bit of advance notice for that. You can book your place, and Irfan and I will be going through the sponsorship route in a bit of detail. And so that brings this episode to a close, and thank you to Irfan, Gordana, Charlotte for joining me here today, and thank you for listening. Do comment and like and subscribe as people do, and do keep an eye on our website so we can keep you up to date with the latest immigration news, and see you next month with the latest immigration insights. Thanks all. Bye-bye.